Hey y'all, it's Kim. So this is the second video for a lawsuit that was filed between Virginia Giuffre against Prince Andrew. Anyway, this is just the continuation of that. This document is kind of screwed up, and I don't know why it looks like all terrible, but I didn't write it. I'm just pulling stuff off the internet, so somehow it got all screwed up. But anyways, this is the 2009 agreement. The 2009 agreement is the crux of defendant's motion. It contains 6 and a fraction pages of substantiate, I guess, consisting of 9. I don't know. Who the hell knows? Okay, so these are agreements to dismiss the Florida case. One, a 1.5 page provision captioned general release that contains additional covenants beyond the releasing language. A payment section, the confidentiality provision, covenants dealing with maintaining Giuffre's anonymity, a no contact covenant, a provision relating to governing law, I guess, and enforcement of the agreement, a clause concerning attorney's fees, and the collection of miscellaneous provisions. A number of these provisions bear importantly on the resolution of this motion and are discussed in detail below, so there is no need to quote or summarize them in great detail here. Suffice it to say, by way of introduction, that this motion raises 2 pivotal issues regarding the 2009 agreement. Whether the 2009 agreement demonstrates that its releasing language in Section 2 unambiguously applies to the defendant, and if so, whether the defendant, who is not a party to nor mentioned in the agreement, is entitled to invoke it. The 2009 agreement is far from a model of clear and precise drafting. Both sides agree that Epstein and Ms. Giuffre agreed to its language. It must have meant something to them, but Ms. Giuffre and the defendant in this case disagree emphatically as to what it meant with respect to both issues. Discussion, basis of the 2009 agreement is not justified on this motion. Legal principles, materials properly considered. The defendant moves to dismiss pursuant to Rule 12b-6. As noted previously, the court in this posture must accept as we all well pleaded factual allegations in the complaint and draw all reasonable inferences that can be drawn from them in the light most favorable to the plaintiff. With limited exceptions, the motion must be decided solely on the basis of the allegations of the complaint without regard to any extraneous claims or materials. The 2009 agreement neither appears in nor is referred to in the complaint, but the copy before the court concededly is authentic. Its wording, as distinguished from its legal effect, is disputed, and the court consequently has taken judicial notice of it. Moreover, notwithstanding the general ride that an affirmative defense is not considered at this stage of the litigation, something about defense may be raised by a pre-answer motion. I don't know, dismissed under rule. That's all screwed up. If the defense appears on the face of the complaint, and while the defendant's argument does not rest on the face of the complaint, here that is a distinction without a difference in light of the fact that the wording of the 2009 agreement, again, as distinguished from its legal effect, is accepted by both parties. Accordingly, the court considers defendant's argument. So the governing law, the 2009 agreement provides that it shall be governed by the laws of the state of Florida. The parties agree accordingly. The court applies Florida law to the 2 pivotal questions that bear on the defendant's release argument. Analysis of the 2009 agreement, whether the defendant is among the purportedly related persons. We begin by focusing on the first 2 pages of the 2009 agreement, which contains sections 1 and 2. Section 1 contains the agreement of plaintiff and Giuffre Epstein to dismiss plaintiff's Florida case upon receipt of a monetary payment. Section 2, which occupies 1.5 typewritten pages, contains, among other things, language by which first parties, generally Ms. Giuffre and some others, release second parties, generally Epstein and some others, and any other person or entity who could have been included as a potential defendant. Other potential defendants from all manner of claims that said first parties ever had or may have against Giuffre Epstein or other potential defendants. The defendant insists that he was among the other potential defendants and therefore was released by Ms. Giuffre from all manner of claims that she ever had against him. Ms. Giuffre maintains with equal adamancy that he was not among the other potential defendants that the parties to the 2009 agreement had in mind. The basic principles of Florida law that govern this aspect of parties' dispute are clear. Unless contract language is unambiguous and free of conflicting inferences, ambiguity must be resolved as a question of fact. In other words, unless the terms of an agreement leave no reasonable doubt about the intent of the contracting parties, the ambiguity must be resolved by the trier of ordinarily a trial. What? Trier of an ordinarily a trial jury, whatever. The court may not resolve any such ambiguity on a motion to dismiss the complaint. Whether a contract is ambiguous is a question of law, specifically whether the agreement in whole or by its terms and conditions is reasonably susceptible to more than one, interpretation. That is so even where both sides insist that language is unambiguous but ascribe materially different meanings to it. In this case, everyone agrees that the phrase could have been included as a potential defendant. Other potential defendants must mean something. No doubt that is so. Nor is there a doubt that better drafting probably could have eliminated any uncertainty as to the meaning. In fact, however, the meaning of the phrase is far from self-evident for a number of reasons. We perhaps should begin with the question of what is meant included as a potential defendant, as opposed to could have been included as a defendant. One might suppose that whether one was, could have been included as a defendant, not included as a potential defendant, is clear enough. Although even that seemingly simple supposition, as we will see, is not accurate in the context of this case. But the concept of inclusion as a potential defendant is even less capable of definition. If the quoted language from Section 2 of the 2009 agreement, that is, the phrase could have been included as a potential defendant. This is nuts. Yeah. Indeed, we might have begun with the fact that the 2009 agreement defines other potential defendants as any other person or entity who could have been included as a potential defendant without specifying in what. Defendant's brief sought to solve that problem by asserting that the 2009 agreement defines other potential defendants as other persons or entity who could have been included as a potential defendant in Giuffre's lawsuit against Epstein, despite the fact that the italicized words do not appear in the 2009 agreement. Plaintiff, however, takes the same view. See, whatever the 2009 release by its terms encompassed only claims against Epstein and other potential defendants who could have been included as a potential defendant in the Florida complaint. Accordingly, the court accepts the parties' agreed gloss on this point for purposes of this motion. Oh, gosh. Let's see. Something was intended to mean someone who was not actually a defendant when the 2009 agreement was signed, but might have been made a defendant previously. Damn, this is so screwed up. Okay, if something had named him or her as an actual defendant, then the word potential would be entirely superfluous. That is so because the language would mean exactly the same thing with or without the word potential. Put another way, damn, break it down. Okay, the phrase under consideration, under consideration would mean exactly the same thing, even if one deleted the word potential entirely. Good grief. Yeah. Why is this all screwed up? I don't understand what's all these letters. Okay. Uh, I think it's saying something like if a basic con- contract something be construed wherever possible in a manner that gives meaning to every word and phrase, the presumption is that contracting parties do not include words or phrases for no purpose. Nevertheless, the parties have briefed this matter as if the word potential were not in the agreement at all, and as the court sees no other appropriate course, it will do so as well. It sees no way to construe it in a manner that will give non redundant meaning to the word potential. Damn, this is like, okay, I'm going to stop it here. This is a really screwed up copy. I mean, it really is, but I'll keep reading it. Uh, this is just terrible. But anyway, I'll start over or start another one soon enough. All right, talk to y'all later. Bye.